Yes, what happened? Mr. T. Tara was there yesterday. Anyway, none appeared for the petitioner on call list. In the next available match or next list after 2 weeks. I don't know.
May I, Lordship. May I, Lordship. Lordship, this IAS for condoning the delay, Lordship. A delay of 58 days has occurred, Lordship, in filing the connected appeal, Lordship.
One of these are 28.5, wherein the delay was and not to be properly explained, so we understood when we find an motion.
Yes, so have you explained, can you explain the delay of 58 days?
Yes, the explanation is, Lordship, with paragraph 12 and 13, Lordship.
Additional affidavit.
Yes, additional affidavit I have filed, Lordship.
So
Further
what-
explaining the
so
delay,
have
Lordship.
you explained properly there?
Yes,
No
Lordship.
appeals, conviction are statutory appeals, but let's see, what is the explanation given to you by you? Yes,
Yes, Lordship. The judgment and order was passed on 24th January 2024, Lordship. Thereafter, Lordship, the family member took out got the certified copy of the entire records on 6 March 2024, Lordship. Thereafter, they rushed down to Guwahati. However, due to certain disagreement with the advocate in Guwahati, Lordship, they couldn't file on the time, Lordship. Again, they came back to Naharlagan, Lordship, after having a consultation with the advocate in residing in Naharlagan, Lordship. Thereafter, only, Lordship, they could have filed. And due to certain financial conditions, also, Lordship, the delay has been caused, Lordship.
yes. Anything else?
Yes, Your Lordship, I don't have any objection to.
Objection? Because this is statutory
Statutory.
need from there. Good, Mr.
Key time, Lordship.
Heath again, learned counsel for the applicant who has filed the instant application under section 5 of the Limitation Act, 1963 for condonation of delay of 58 days in filing the appeal against the judgment and order dated 24/01/2024 passed by the learned district and judge, Bomdila, West Comment District in session case number 08/2023, convicting the applicant/appellant under section 376 and 302 IPC, wherein the convict was sentenced to suffer 10 years imprisonment under section 376 IPC with a fine of ₹10,000 and to suffer life imprisonment and a payment of fine of ₹20,000 on his conviction under section 302 IPC with a default clause of payment of with a default clause on the payment of fine to serve another 3 months aside. The learned counsel for the applicant submits that there is the reason for the delay in filing the appeal has been explained at paras
Para 12 and 13 of the IA.
12 and 13 of the IA application and at
Para 3 of the additional affidavit.
para 3 of the additional affidavit, which is mostly due to the fact that time was taken for obtaining certified true copies of the judgment and order and to collect the required documents. And also time was taken to engage counsel to represent the applicant slash appellant. And also due to certain financial constraints faced by the appellant. Heard Miss So-and-so, learned
DG.
additional PP has not raised any objection to the condonation of delay of 58 days. In view of the above, we have perused the relevant paragraphs in the application and the additional affidavit filed by the applicant. And we find that since no objection is raised, we are satisfied with the explanation given, and accordingly, the delay of 58 days in filing the connected appeal against the judgment and order, copy paste, okay, is allowed, and IA so-and-so stands disposed. Yes, disposed of.
Lordship,
Yes,
notice may be issued on the
okay, now the main
Mail
appeal,
Mail.
the main criminal appeal, the main case. You put up only the IA.
another IA under 389 Lordship
Hmm.
for suspension. Notices may be issued on Lordship.
There's a criminal appeal. Now, where's the other IA? Put up on the files. But we'll have to admit your appeal first, isn't it?
Yes.
Before considering the other IA. Yes. What are the reasons for the filing the appeal?
Yes, Lordship.
Grounds.
Lordship, the grounds for filing the appeal is that Lordship, the only only grounds that the conviction was granted or was given was on the DNA on the basis of the FSL report, Lordship. However, there are two different FSL reports. Both of them are contradicting. One says one is negative, one comes negative, and the other is positive. And on the other hand, Lordship, there is no any corroborating evidences beside the FSL report. That is the main reason, grounds.
Heard, no, on the disposal of the condonation of delay application in IA 47/2024. Heard Mr. So-and-so, learned counsel for the appellate. This is an appeal filed against the judgment and order of the copy paste, okay, and so. The learned counsel for the appellant submits that there are sufficient grounds for setting aside the judgment and order of the learned trial court dated 24/01, 2024. And submits that the main grounds being that the learned trial court had erred in convicting the appellant under sections 302 and 376 IPC. Mainly on the grounds of the FSL report, which are contradictory, okay. And also for not appreciating the evidence in the proper perspective. Appeal is admitted. Issue notice to the state respondents. Ms. So-and-so, learned additional PP accepts notice on behalf of the state respondents. No need to issue formal notice. Yes.
May I pray, Lordship? Lordship,
Respondent number 2.
respondent number 2, through
Okay.
a jurisdictional police station, Lordship.
Okay.
Notice.
Issue notice to respondent number 2. Through the
Jang Police PS, Lordship.
Jang Police PS, is it?
Yes, yes. West coming.
West
Coming.
Carmen. Okay, but additional people also take steps?
Yes, in fact, your lordship, if the step is taken by them through routing through the office of the PP, that would be much more appropriate.
Must, because you have read them as this thing.
Lordship.
party, okay. Necessary steps is to be taken by the learned counsel for the appellant. List the matter after 3 weeks.
Obliged.
Meanwhile, your lordship also may call for the
Meanwhile,
LCR.
LCR is to be called. Yes.
My lord, I am extremely sorry because I got delayed by 3 minutes reaching courtroom. Item number 1, my lord. Is a
We'll fix
contempt.
it for after 2 weeks.
My lord, kindly.
Okay, this is motion stage.
Notice,
This,
notice,
okay.
my lord.
Contempt is with regards to non-compliance of what?
Is a order passed by the division bench. There was, my lord, the fact is like the single bench, I have moved the writ petition. No interim was granted. Then we assailed that impugned judgment of the learned single judge before the division bench, and the division bench was given the interim order, and it was finally made absolute, my lord. Made absolute by this order, my lord, 3335. And thereafter, my lord, the contempt number, alleged contempt number 1. My lord will kindly come to page 23 first. Order passed in writ appeal number 6, 2024. In the interim, the order number so and so dated so and so passed by the Commissioner Urban Affairs, Urban Development and Housing, Government of Arunachal Pradesh State until further orders of this court. Then, my lord, then finally, kindly come to page. My lord, kindly come to page 35. This another order passed by this interim order was made absolute by this order. Taking note of the submission made at the bar.
Submission notice.
Yes, my lord, only notice.
Heard Mr. T.T. Tara, learned counsel for the petitioner, who has filed the instant petition / application under section 12 of the Contempt of Courts Act, 1971, read with Article 215 of the Constitution of India and Rule 9 of the Contempt of Courts, within brackets, Guwahati High Court, close bracket, rules, 1977, for the disobedience and non-compliance of the orders / directions passed by this court in WA number 06/2024 on 29/01/2024 and 29/04/2024. When this court had stayed the operation of the order dated 02/12/2023, passed by the respondents, issued by the respondents. Issue notice to the respondents. Yes, state who's
No,
appearing.
my lord, contempt.
Okay,
Personally, not
okay,
same.
okay, yes,
Minutes.
issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks.
3 weeks.
Just after 3 weeks. Yes.
Great, much obliged.
Yes.
Your Lordship. Lordship, this is also a condemnation application, my lord. My lord, there is a delay of 371 days in filing, my lord, connected writ appeal, my lord. And
Okay, will issue notice. Will issue notice.
My-
Yes.
Heard Mr. M. Kato, learned counsel for the applicant, who has filed the instant application under section 5 of the Limitation Act for condonation of delay of 371 days in filing the connected writ appeal against the judgment and order dated 13/06/2023, passed by the learned single judge in WPC number 56/2023. Issue notice to the respondents. Mr. So-and-so
Madam, I am for respondent number 2 and 4, madam.
accepts notice on behalf of respondent number 2 and 4.
Mr. Kandu, can you please come here? You do responding number 3.
The others,
Yes, my lord. Respondent number three,
Take it, we-
by
yes, madam.
Mr. Kambal accepts notice on behalf of respondents number
3,
Three,
madam.
my lord.
3.
Three.
What about 1?
My lord,
One
one
is
is the private
private
respondent,
respondent,
my
my
lord.
lord.
Petitioner,
So,
my lord. I'll take it.
Notice is to be
Noted.
issued upon the private respondent number 1
Madam.
through registered post with AD within 3 days,
Madam.
returnable by 3 weeks.
Madam.
List after 3 weeks.
Madam,
On a
two-
date
two-
fixed
two
by
weeks,
the
madam.
registry.
At least after 2 weeks.
Or 2 weeks,
My lord.
okay, list after 2 weeks.
Madam.
On a date fixed by the registry. Yes.
Maybe ask the parties to us.
I requisite, meanwhile, requisite,
wait.
extra copies of the,
There are so many things to be, my lord. First condemnation delay, then stay, then my lord. Once the condemnation delay, then my lord requisite copy may be served, my lord.
of the IA, you need the IA,
IA.
requisite copies of the
IA.
IA application to the learned councils for the
My-
respondents.
Development.
क्या करेगा, आएगा नहीं.
29.
Yes,
Lordship,
That's
conducting
in
council
your-
for Lordship.
supplementary hearing.
Yes, Lordship.
Yes, okay.
Lordship, conducting counsel for the petitioner, Mr. Pangin had some difficulties today, Lordship. So kindly this matter may be taken up after 2 weeks, Lordship.
Mr.
B. Lona
The lawyer, learned counsel
for the petitioner,
for the petitioner,
FLN.
Yes. for the appellant. Yes, 29 is an appeal. Has prayed for adjournment of the matter with the consent of the respondents. In view of the above, list after
2 weeks, Lordship.
2 weeks.
And Lordship, item number 30 also, Lordship.
Okay, you are for the
I am for the,
appellant.
yes, Lordship.
Okay, same order.
Same, Lordship. All right, Lordship.
My lord, I beg to mention item number 8, my lord. Item number 8, my lord. My lord, we are supposed,
Supplementary hearing matters, we will do 8, you wait, it's quite,
my lord.
it's, this is number 8, you can wait, no? Hearing matter, adjournment?
Yeah, my lord.
26.
20.
26, 27, 28. All of them are analogous matters listed together, isn't it? Is it
Yeah, madam.
correct? Yes,
I beg to mention item number 20.
20,
Yes,
28,
20.
20.
With the consent from the other side. Here, my lord, we have filed one IA impleting all the victims' party respondent, my lord. Here.
So you wait for your turn, you wait for your turn. We are looking at supplementary hearing first. Okay, lest they are listed, orders will come. We'll call out the matter. Okay, just wait. Anyone for item number 26? Listed,
Your Honor,
yes, adjournment. Good.
Item number 26 to 28, Your Honor. Here I have been instructed to file wakalatnama for the petition appellant, Your Honor. As,
Why, what happened? Previous,
yes, Your Honor.
now here there are councils appearing.
For appellant, in 26, I'm for the appellant and rest for respondent number 2. 27, 28.
So you're going to file a wakalatnama?
Yes, Your Honor.
But there are councils here
Yes,
appearing.
I have taken the concern, Your Honor.
Okay,
Concern has been taken.
third, Mr.
B type of, yeah.
B, so-and-so, learned counsel who submits that you will be filing his wakalatnama to represent the appellant with the consent of the councils.
Yes, yes.
You filed, you are going to file.
I'm going to file.
Okay, you will be filing wakalatnama within the course of the day. In view of the above list. Okay, and then in the other cases,
Your Honor,
27 and 28, you will be for the respondent.
yes, Your Honor, for respondent number 2.
Item number 27, his name will be filing wakalatnama for respondent number 2 with the consent of the previous council. And 28,
Same, respondent number
Okay,
two.
respondent number two, same orders, okay. In view of the above, list after 2 weeks.
2 weeks.
2 weeks.
Sure.
Not a
Your Honor,
date fixed by the registry. Yes,
Your Honor, there's one more to, if Your Honor's allowed. Item number 18 and 19, Your Honor. Here, Your Honor, I have just received the paper book yesterday, Your Honor. So matter maybe
this is
it in order.
18 and 19.
Yes, Your Honor. Paper book has been received.
So it will be listed for hearing when the matter comes, be
Yes.
listed for hearing.
After 2 weeks, Your Honor.
Most probably, let's see when the matter comes up, no?
Lordship, this is transfer petition, criminal. Is transferring the case from district and session judge, special judge, this Postco to Dashboard.
Hmm.
In this case, kindly see Lordship, this FIR, page number 13, annexure 1. This is the FIR laws by the principal Kasturba Gandhi Balika Vidyalaya, Salari, West Caming District, Arunachal Pradesh. What has happened? FIR has been lodged by the principal saying that the FIR regarding missing of 2 students of KGBB Salari. Accordingly, case was registered under this kidnapping. So this criminal law was taken into motion or investigation of the case. Accordingly, the IO of the case has investigated the matter. During the course of investigation, what had happened? This page number 18, this annexure, page number 18, this second last paragraph. This is relevant. Under the given fact and gravity of the instant case, it is praised to the independent district and session judge court for adding section 342-34 IPC read with section 4 and 8 of the POCSO Act 2012 in place of registered section under 363 IPC. So IO has found that it is not a case of kidnapping.
It's not kidnapping.
Yes, not a case of kidnapping, but the IO has revealed that in the page number 19, this charge sheet report, both this victim girl came here this at Tezpur for in charge of Sri Dhanmani Das asks where they have come from and purpose for their visit to Tezpur. In this, the victim girl replied,
This is a bail application for release of the accused who was arrested on 14/12/2023. Now it's more than 6 months. He is in jail. In this case, even charge sheet was filed. But only the issues was that they had not filed prosecution sanctions to be prosecuted under section 10 and 13 of UAP Act. So the session court, Honsa, had sent the case record for trial to the JAM agency. The order is in page number 22.
Yes.
It's record, although the IO filed charge sheet against all accused present under section 384, 507, read with section 10 and 13, UAP Act. I, in absence of prosecution sanction, find no reasons to take cognizance of the offense under section 10, 13 UAP Acts. As the offense under section 384, 507 IPC is tribal by the judicial magistrate first class, let the case record be transmitted to the court of learned JMFC, Honsa for trial. Now, since this was transmitted, now the case is pending without even the charge sheet is not framed till date. So they are just as a routine manner, they are remanding the accused to judicial custody. So which is a clear violations of the right.
Will you show notice?
Yes,
And then
call
we'll
for the
fix the date.
LCR.
Yes, we call for the scanned copy. Okay, heard, Mr.
DK Devre.
So learned counsel for the applicant who has filed the instant application under section 439 of the Code of Criminal Procedure 1973, read with article 226.
No, no, that's just
Ah,
on it.
please, not 226 here, okay? What?
439.
But
Only
you have
439.
made it here in your application?
No,
Yes.
that was wrongly written. I'm
What
sorry.
wrongly written? It's here in writing, so,
Yes, so because 20 was violations, I am kept in jail without trial,
hmm.
even though there is a directions. Other, even with prosecution sanction also, a trial can be initiated.
439 of the Court of Criminal Procedure for grant of bail to the accused arrested on 14/12/2023 in connection with Deomali Police Station case number 13/2023 under section 384/507/34 of the Indian Penal Code, read with section 10/13 of the Unlawful Activities within brackets Prevention close bracket Act, and is presently lodged in judicial custody, comma, sub jail for Nasa. Issue notice to the respondents, Mr. So-and-so, learned
Additional people.
additional PP accepts notice on behalf of the state respondents. Requisite copy of the bail application to be duly furnished to the learned additional PP. List
On 7th of August,
on 7th, 8/2023.
Your
Meanwhile,
Lordship.
scanned copies of the CD is to
So
be
LCR,
filed.
Your Lordship.
Okay, this is
Charge sheeted.
LCR.
it
Charge
is already
sheeted.
charged.
Charge sheeted.
Already charged
Yes,
sheeted.
yes.
Okay, meanwhile, scanned copy of the LCR is to be called for. Yes.
Deeply obliged.
Yes,
Lordship, this is a pre-arrest bail application. Lordship, let us go through the FIR first. Page number 18. Lordship, may kindly come to page number 18.
yes.
Marriage. I, Srimati so-and-so, wife of so-and-so, presently residing Pasigat, hereby lodge this FIR against Dr. So-and-so for instigating Sri so-and-so and others for committing house trespassing, vandalism, and attempt to murder at my residence located in GTC area adjacent to Perme apartment. On dated 21st July 2024, I discovered that my house has been trespassed and the following items belonging to my brother-in-law, Sri so-and-so, were stolen: a gold bracelet worth rupees 50,000, 53,000. 5 lakhs 3,000
56.
and 1 lakhs 56,000.
Ah,
Furthermore, my brother-in-law, Sri so-and-so, scooty bearing registered number AR25409, 50 numbers of CGI sheets were completely damaged. Chain link fence measuring 47 meters and 35 numbers of angle posts were been taken away by the group. Therefore, I request you to register this FIR under appropriate section. This is the FIR. Now, this FIR comes because of a land dispute. So there was a land dispute, and accordingly, because of land dispute, this land belongs to the against whom the complaint FIR was registered, Dr. Tariq Talong. The land belongs to him. The informant has encroached in the land, and because of that, there was dispute. And a
how can
family,
you say that?
Lordship, I have annexed also.
Where?
Page number 12. Page number 12 is the Kaba order, where first Kaba order.
So if there's a land dispute,
Yes.
he has a reason to instigate those
Lordship,
people.
let me finish. Lordship, in the second Kaba decision also, there was two Kaba decision. First Kaba decision, it was decided that the land belongs to against whom the complaint was registered. And again, in the second cover decision, where it was again decided the land belongs to him, and 1 month time was given to the other party who has encroached, the complainant, to remove the hut that she has constructed. And if she fails to remove in 1 month, the person against whom the FIR was lodged was given liberty to remove by itself. Lordship may kindly come to page number 15. That's a type copy of the cover decision. Point number 4. Lordship. The Kaba has decided that the house built in the land of Sri so-and-so should be removed within 1 month. In case if not removed within 1 month, the Kaba has decided that Dr. So-and-so can remove it himself. Now, after 1 month, he has approached the informant to remove the said illegal construction, whereas she refused to do so. So he has peacefully removed the unoccupied hut. Now, if the informant were unsatisfied with the cover decision, they ought to have challenged before the appropriate court, Lordship. Instead, they have registered a false FIR stating that they have stolen certain amounts of things, whereas the hut which was removed peacefully was unoccupied. And this is clearly a civil dispute, Lordship. By lodging this FIR, the informant is trying to make unnecessary allegation with baseless.
So FIR has been registered? No.
Yes, registered, and a notice was also issued under section 35, 3 of BNS.
Where?
In page number 19, and directed the accused persons to appear before the Pasigat PS on 25th, tomorrow, Lordship.
So let them appear, what's the problem?
He is willing to appear. There's no problem. He will appear, just interim relief, so that he has apprehension that due to some foul play, he might get arrested. But it is clear from the records that this is a civil dispute. And against whom the FIR has been lodged, Lordship, Dr. Tarik Talom, Lordship. He is a well-established person, Lordship. He is a DMO at Boleng, Lordship. He is a well-respected person. And
So who is the applicant for AP?
for this,
This is someone else.
Kukut
Kutuk
Talom.
Talom. He's not a doctor.
Second application, the same. There's 2 accused persons. The FIR was lodged against Dr. Tarik Talom for house trespass.
But see, something had happened. Scooter was damaged.
No, there is no issue. It was unoccupied hut, Lordship. It was peacefully removed, and accordingly, in the second bail application, against whom the FIR was lodged, he has also lodged a counter FIR.
See, cognizable offenses there, they can arrest straight away. So you're saying that no scooter was damaged?
No, Lordship, it was a unoccupied property, and according to the Kaba decision, he has followed the decision. After 1 month time was given to the person to remove the occupied hut, but she refused to do so. After 1 month, he has sent some relative to remove the said hut peacefully, Lord. And in the Kaba also, there was also fine was also imposed against the informant, because she has forcefully removed an iron gate which was put by the accused person in the said property. They ought to have gone to the appropriate court challenging the Kaba decision.
See, even if you're unhappy, that doesn't give you the rights to do some criminal act, isn't it? So
Absolutely
whether
not.
some criminal act was done or not by you all, that has to be seen.
Absolutely not.
Here, FIR was registered
On 21.
under section?
Section section
Three-
305A
What
and
is 305?
305 is, theft in a dwelling house. And
In a
3
dwelling house. So
yes.
you're saying this is not a dwelling house?
No, Lordship, it was a unoccupied house, or hut, Lordship. Three zero five A, Lordship.
Hmm.
And second section is Lordship. Mischief, 324. 324. Three 24 for 304, the maximum
See, now here, this is okay, this is, now we have used the BNS.
yes, Lordship. Because the FIR was
Yes,
registered. on-
yes, now it's correct.
Yes.
Hmm.
There's apprehension that he is willing to cooperate, Lordship. He is willing to go to comply with the notice given by the police. It's just that he has apprehension that due to some foul play, he might get arrested. That's why interim relief is prayed, Lordship. Otherwise, he is willing to cooperate. And it's clear that the Kaba decision is there. It's clear that it's the whole incident arose because of a civil dispute, Lordship.
Yes, okay, will issue notice?
Lordship, interim relief may kindly, because tomorrow he has to go to the police complying the notice. And he's willing just interim relief. And
Yes,
because
heard,
this is a civil
heard,
dispute.
yes, heard, Mr. So-and-so. Learned counsel for the applicant who has filed the instant application under section 482 of the BNSS. Okay, make it the full form, okay, Bharatiya Nagarik Suraksha Sanhita, 2023. Praying for grant of free arrest bail in connection with FIR number 95/2024, registered under section 305 within brackets A/324 within brackets 4 of the BNS dated 21/07/2024 in the police station of Pasigat, East Siang District, Arunachal Pradesh, full stop. The learned counsel for the applicant submits that the FIR filed against the applicant dated 21/7/2024 is a false allegation, which is actually due to the land dispute between the informant/complainant and the present applicant. He submits that no acts as alleged under section 305 within brackets A/324 within brackets 4 of BNS has been committed by the applicant and that the applicant is now summoned to appear before the police station, which place?
Pasigat.
Pasigat. On, what's tomorrow's date?
25.
25, 7/2024. The learned counsel submits that if interim protection is not given to him at this stage, he fears that he would be arrested for an offense which was not committed by him. Stop. Issue notice to the respondents, Mr. So-and-so, learned additional PP, accepts notice on behalf of the state respondents. What do you have to say before the disposal of the final disposal? He's praying for an interim relief.
Yes, it may be granted because maximum punishment here is 7 years.
Okay,
And,
the learned additional PP has not raised any objection to the interim relief prayed by the learned counsel for the applicant in granting interim bail to the applicant. Since the maximum punishment in the sections charged,
305A.
that is 305A IPC, is 7 years
Yes.
only. Having heard the submissions made by the learned counsels for both the parties, this court will find it fit to grant the bail to the applicant with a bail bond of rupees 10,000 with one surety of the like amount, which shall be to the satisfaction of the OC, police,
OCPS.
OCPS Pasigat, in the event of any arrest of the applicant. This is matter. Meanwhile, requisite copies of the bail pre-arrest bail is to be furnished, duly furnished to the learned additional PP. List after 2 weeks.
Yes.
CD may be called.
CD may be called
Meanwhile, CD to be called for. Yes.
after 2 weeks. Problem.
What about the other one? Same.
Same.
Arranging of same.
Sections the same.
Same sections, same FIR, everything is, only the applicant is.
Let's see the FIR. It's the same.
In this application, only addition is the counter FIR.
Okay, where's the counter FIR?
Page number 20, type copy of that FIR.
Okay, so in this case, everything else will be the same. Only thing is, before issue notice, okay. Before that, we will add this line. The learned counsel for the applicant further submits that since this case is arising out of a civil dispute, the applicant has also filed a counter affidavit, a counter FIR against the informant. for registration for filing an FIR against him. Okay. Stating that the said FIR is amounting to his defamation and also for spreading misinformation and creating communal disharmony. Okay, full stop. Then issue notice, so and so same. Yes. Yes,
Proceed may kindly peruse the order dated 17/6/2024. Since the affidavit has not been forthcoming, that order was passed.
Hmm.
On the last occasion, they said they will be filing, but they have not yet.
So you're supposed to file your affidavit, isn't
May I
it?
please, my lord? My lord, I appear on behalf of the AGIM Kato, my lord, for respondent number 1, 2, 3, and 4. My lord, this morning we filed our affidavit and it is in under process.
Okay. Mr. D. Pangin, learned counsel for the petitioner, is present along with P. Sangeeta, learned government advocate for respondents number 6 and 7, and Mr.
And Sora,
M. Sawan, counsel for respondents number
1,
1,
2,
2,
3,
4.
and 4.
1, 2, 3, and 4, 1 to 4. isn't it? The learned counsels for respondent number 1 to 4 submits that they have filed the counter affidavit this morning itself. And the matter is under process.
I have not received the report.
Okay. In view of the above, copy of the counter affidavit to be duly furnished to the learned counsel for the petitioner. This after 2 weeks.
Okay.
Yes, what is the
Your
state?
Lordship, during the last occasion, this one court directed to file me counter reply in person to private response number 3 and 4. So I have already filed affidavit reply on 8.
So pleadings complete? What?
We need some more time to file rejoinder according to their concession made in affidavit in reply.
Your Lordship, I challenge the legality and validity of the order passed by the respondent number 2, that is Deputy Commissioner, whereby he called back his own order after lapse of 5 months. In person to I come here before this Honorable Court, only
See, you
one
have filed
ground.
a counter affidavit. And they are the ones who have filed a rejoinder affidavit to your counter affidavit file. What? This will never end. So pleadings are complete.
Instructed by my senior,
Huh?
we need to file rejoinder.
Your Lordship, I am disputing only act done by the respondent number 2 only, that is Deputy Commissioner, whether he has jurisdiction
So you're for respondent number 2.
3 and 4.
private respondent.
So have you filed your affidavit?
Yes, we
Yes.
have filed, but.
In person that I already filed my affidavit reply on 8.
So we'll hear the matter now. You have filed a counter affidavit. They have filed their reply to your counter affidavit, and that's it.
That's it, but as instructed from my senior.
Yes.
And
Okay, for instructions.
Whether we are not here.
Yes.
legal title.
You don't know anything concerning the case. He's just repeating what his senior has told him, isn't it? Heard, Mr.
Yes, Titokur.
T. Thakur, learned counsel for the petitioner, along with Mr. Yes,
For
Miss.
respondent number 2.
So and so learned government advocate for respondent number 2, and Mr. Mr. So and so appears on behalf of his senior
And father. on behalf of NPAT for respondent number 3 and 4.
For respondent number 3 and 4. The learned counsel for respondent number 3 and 4
Can we respond number?
has prayed for listing of the matter after
3 weeks. No, no,
weeks.
sure the payment given. They have
After
already
2
taken
weeks, after
6,
2 weeks.
2 years.
Okay,
have taken
after
already 2 years, yes.
weeks, since his senior is not able to appear today.
The lordship fixed date may be given on that.
In view of the above, list after 2 weeks. Meanwhile, interim order passed earlier shall continue till the next date. Okay,
Much obvious.
let's see what he has to say. Yes.
I'm appearing on behalf of G Talo. He's the
Uh.
counsel. Lordship, I was informed that they need some time to file additional affidavit. This is a joint petition.
Additional affidavit.
Additional.
Mention is made on behalf of
G
Mr.
Talo.
G. Tara, learned counsel for the petitioner for adjournment of the matter and for further time for filing of the additional affidavit.
Kindly.
None appeared for the respondents. In view of the above, list after,
On 8th August,
list on 8/8/2024.
there is an interim. Kindly it may be continued.
Pardon?
There is an interim. Kindly it may be continued.
Meanwhile, interim order passed earlier shall continue till the next adjournable date. Yes.
Table of it.
Item number 8.
My lord, here we're supposed to file additional affidavit, my lord. So, my lord, matter may be listed on Monday, my lord. Meanwhile, I will file additional affidavit, my lord.
Okay, Mr. So-and-so. Learned counsel for the petitioner has prayed for further time to file the additional affidavit. List in the next week. Okay, on a date fixed by the registrar. In the next week, only date.
Obliged.
May I sign, my lord?
Yes.
Lord, record is there, my lord, and party are represented, my lord. My humble submission would be for
Number
disposal, my lord.
7. Affidavit not filed yet.
Lord, this record is there, my lord. This is a criminal petition, my lord. My humble submission that this case can be disposed of, my lord.
Yes. Are you going to file or no?
Your question of law only.
Oh.
The first part, I concede that none of the ingredients of the Indian Penal Code is not against the applicant, but from our side, there is a material under Section 3 of PDP Act 19. So only that, to that extent, may not be disposed. They can file at the time of consideration of the charge. They can file discharge application and dispose of it. Whether the court finds sufficient material, then please proceed or drop the charge and I think that will be sufficient.
Okay, we'll fix another date. Okay. Heard Mr. So-and-so, learned counsel for the petitioner, along with Mr. T. Tara, learned counsel for respondent number 2 to 7, and Mr. So-and-so, learned additional PP. The learned counsel for respondent number 2 to 7 submits that though it was noted in the previous court date that they were to file the affidavit, counter affidavit, however, he submits that filing of a counter affidavit may not be necessary in the instant case. In view of the above, this matter may be heard in the next week.
Day after tomorrow, my lord.
Pardon?
Day after tomorrow, my lord.
Day after.
In the next week, on a date to be fixed by the registry.
Listen, make it 2 weeks. No, in between, I will be
What?
out of station. In between, I will be out.
Okay. Okay, so list, you want a date after 2 weeks on?
No, not after 2 weeks, my lord, day after tomorrow, my lord. And it's simple case, my lord, other, a short issue, my lord, involved in this case, my lord.
You see,
On the face of report, my lord.
Pass an order also, okay?
My lord.
And besides the CAV spending in this, in this bench, there are some other pressing matters from the other benches also. Okay, so I don't want to overburden myself. It's only not this bench only. Okay, yes. List on, give us a date after next week.
Late date after 2 weeks, my lord.
No, after 2 weeks on a date
weeks by
fixed
the-
by the registry. Yes, yes.
Interim, my lord, is there, that may be kind.
Meanwhile, the interim order passed earlier shall continue till the next date. I don't think there's any pressing urgency in this matter. That's why, yes.
Oh, yes.
Your Honor, the leading counsel is engaged in court number 2.
I can't hear you. You're wearing a mask also.
Sorry, the leading counsel is engaged in court number 2.
Okay,
So-
time being matter.
Yeah, yeah.
Make it time being. Yes.
Yeah.
Then I thought we just said a time being.
No, it was.
Counsel for the private respondent is engaged in court number 1 or 2.
For 10.
Yes, my lord.
So now we will do 11.
This is 10, my lord.
This mean, then I'm the legal petitioner, legal counsel, yeah,
Okay.
yes.
So I thought you were engaged. You're not engaged anymore.
No, counsel for the private respondent is engaged.
So the time matter is made time being, let the counsel for the respondent be present and then we'll hear. We cannot hear your matter without the opposite party being present,
Your Honor.
isn't it? So we said it's a time being matter. When the counsel for the respondent comes, then you time. Okay, yes.
Lord, in item number 11, I have filed an IA for bringing formal a certain interim direction. Lord, the background of the case is,
Yes, where then? Fine. Okay. Item number 12.
11 and 12. Both interlinked, by the same party with a different cause of actions. Let's make a take up the item number 11, WPC number 196.
Well, let the file be produced. Where have they disappeared? Yes, so what
Like you will, let's see the gist of the case, not the background of the case. The matter relates to the construction of a road project from Tato to Mesuka. Now, in 2021, by inviting NIT.
Yes, wait, let's see, what is the state? So what is the IA? IA has been disposed?
I am seeking the certain interim order, so that the writ petition do not become infructuous. In fact, your lordship, in the IA, lordship may kindly have a look to the order dated 3/6/2024 at page 16 in the IA.
Wait. Page?
Page 16.
Yes, so in the IA.
Third paragraph onwards, in this concern, Mr. Learned for the petitioner has submitted that since there is no interim order operating in this case, further adjournment will cause serious prejudice to the petitioner side. However, he further submits that The matter may be listed on 17/6/2024, and the respondents may be directed to file an affidavit in opposition by 10/6/2024. Considering the submission made by the learned counsel for both sides, list the matter again on 17/6/2024, along with a direction to the petitioner to file their affidavit in opposition by 10/6/2024. In the meantime, an endeavor shall be made to dispose of the matter on the next date fixed. But this affidavit has not come forward on the record, so therefore the matter could not be heard. And on the other day, on the other way, the tender that was issued on 1/5/2024, it's near finalization. And once it is finalized and the LOA is issued, in that case, my writ petition will become infructuous. So therefore, I am filing this.
So you're not pressing the IA, okay. IA is not pressed.
I'm pressing the IA.
Pressing the IA. So what about the written objection? Filed, are you going to file a written objection in the IA?
My lord, in IA, my lord, we have not filed, my lord, any, my lord, objections to objection, my lord.
So not objected?
My lord, no, no, my lord, we'll file, my lord, affidavit. Objections to the IA, my lord, we'll file, my lord. My lord, otherwise also, my lord, the joint verification, everything has been done. My lord, whatever, my lord, the petitioners is entitled for the payment, my lord, that will be paid, my lord. But by way of, my lord, this, my lord, the IA, my lord, the work is, the tender, my lord, the remaining work was under, press tender, my lord, that has been stayed.
What has been stated?
My lord, regarding the, my lord,
So the IA, it's not really required to be considered.
There's no stay, therefore I'm filing the IA.
Not finalized, my lord.
There is no stay, therefore I'm filing this instant IA for stay or the maintaining the status quo with regard to the tender, so that the writ petition do not become infructuous.
So.
In fact, what happened, Lordship, in the writ
But
petition,
let me see the previous, so why wasn't this IA disposed of?
if your Lordship looks into the.
My lord, we have already floated, my lord, the NIT, and that NIT is,
Wait,
my lord,
this court's last order. Now, in this order of this court, the council were directed to file the affidavit in opposition. Isn't it?
my lord.
In the IA. But affidavit in opposition in the IA has not been filed. Then in the meantime, this court had observed that an endeavor will be made to dispose of the main WPC, is it?
Well, the affidavit was directed to be filed in the main WPC, so that the WPC can be disposed of.
Disposed of.
But that affidavit has not been filed. And on the other way, the time is running out. The tender which was floated on 1/5/2024, it is near conclusion. So I am filing this IA for an interim protection so that the issue in the writ petition remain live.
Okay.
Let them file the
So
affidavit.
in the main WPC affidavit in opposition, counter affidavit has not been
Has
filed.
not been filed, therefore matter
So
could not
in
be.
the IA also you have to find,
My
are you going to, so we'll give them a short date,
My lord.
final chance, because when was this matter?
It was long back, way back on 17/6 itself was directed to be for making an endeavor to dispose of the matter. Nearly.
But time is being taken again.
Taken
They're
and
not filing
again,
their
they
counter.
have not filed again.
So it's better to dispose of the IA first. But for disposal of the IA also, a counter has to be filed.
Till then, let them file the counter to the miscase, the IA. Till then, status quo with regard to the tender notice may be maintained.
That is the, my lord, my submission, my lord. If, my lord,
Status quo be
my lord,
maintained.
if status quo order is passed, my lord, my lord, the development work will be, my lord, hapered. So therefore, my lord, at this stage, my lord, may I afraid with my lord, we may be allowed to file a.
Positively by the next court date.
My lord.
Okay.
In the meantime, my lord, the entire thing should be bring on record, my lord, and then my lord, endeavor shall be made to dispose of the entire matter, my lord.
Okay, heard, Mr. You
I'm
would name
pleased.
so and so, learned counsel for the applicant. This will be the IA, okay? Along with Mr. Kato, learned counsel for respondents, the respondents. The learned counsel for the respondents has prayed for further time for filing their written objection in the application for stay of the tender, is it?
Gotcha.
Number CE within brackets P BMK dash EPC slash 01 slash 2024 dash 25 dated 01/05/2024 during the pendency of the writ petition. The learned counsel for the applicant submits that there is urgency in the matter, since it appears that though this court in its order dated
3/6.
no, in its order dated, let me just say, 03/06/2024 had mentioned that an endeavor will be made to dispose of the connected WPC, connected pending WPCs.
196.
Wait, we'll just make it like the connected WPCs. Since the respondents had failed to file their counter affidavit in the WPCs, this matter is not disposed of till date. In view of the above, the learned counsel for the respondents are given a final chance to file their written objection in the IA, failing which the court will pass appropriate orders. Yes.
Till then, my lord, at least status quo be maintained. Till then, my lord, whatever is there, let them process, my lord, but then they should not be issuing LOA at least, my lord. A short date may be given. Till then, my lord, the LOA may not be issued even if they finalize. My lord. But otherwise, my lord, my entire writ petition will become, my lord, infructuous.
In the meantime, status quo is to be maintained till the next date. List on.
Short date, my lord, 29th or 30th, my lord. Any day, lord.
List on, yes. When will you be able to file? List on 30, 37/2024. Yes.
Malad, not status quo order, Malad, the status quo order will be again Malad. Malad, if that NIT is Malad, the process of the NIT is completed, Malad, Malad, the barrier is not to issue Malad the LOI, letter of Malad the intent to the Malad the successful bidder, Malad.
Meanwhile,
Malad, instead of Malad,
LOI,
status quo.
meanwhile, instead of status quo, meanwhile, LOI is not to be issued, okay, till the disposal of the
Even if the my lord, tender is finalized, LOA shall not be issued.
Okay, meanwhile, because I don't know what your case is about, okay, meanwhile,
Meaning would be the same.
NIT has been plotted, Malad, for remaining.
just make it meanwhile, no LOI is to
Shall
be
be,
issued.
yes.
Okay, no LOI is, shall be issued till the disposal of the instant.
No, Malad,
IA.
the Malad,
Then what happens,
LOI, Malad, in the meantime, without the leave of this honorable court, Malad.
Okay, okay, without the leave of this court. Meanwhile, no LOI is to be issued without the leave of this court. Okay, yes. Then list on so and so, that date.
The problem.
I don't know, we'll have to look into the case anyways.
May I plead?
Yes.
Attempt 13, lordship.
13.
Lordship, this is the application under section 438 of CRPC in connection with Chimpu PS case number 13/2024, which was registered under section 120B 419-420-468-471-379-384 of IPC. The main FIR is at page 15, Lordship. So this case.
We have received the CD, Your Lordship. Have been, as per the status report of the CD, Your Lordship, the applicant here is cooperating with the investigation, Your Lordship. Only the main accused, he is absconding till date. However, he's cooperating with the investigation, Your
So
Lordship.
we'll grant.
Yes. I've just received the CD today morning.
Okay, heard, Mr. Yes, but how? What is the FIR about?
Lordship, FIR was relating to some sex stealing case. So my name is not there in the FIR. The accused had stolen one FIR and thereafter some amount was transferred to my account. Subsequently, one phone call came to me from the concerned police, which I have mentioned in my petition. And at paragraph 4, page 3 of my petition, thereafter, paragraph 4, page 3, at about 11:30 a.m. on 8 February 2024, a phone call came to the petitioner from one of the bank officers of Chotia branch, who informed that the petitioner's bank account was blocked as because the said check of rupees 20 lakhs was illegal. After a while, a police official from Simpu police station talked to the petitioner over phone and said that Tridip Soikia had transferred a huge amount fraudulently on 6 February 2000 and subsequently made payment of rupees 20 lakhs to the account of the petitioner. And as such, the petitioner need to appear before him for investigation purpose and also to refund the check amount. Accordingly, the petitioner had requested his banker to refund the money as per the advice of the police official, and subsequently his bank account was unblocked. So we were ready to refund the
Okay,
money.
so you were asked to appear before the
IO.
Chimpu PS. Okay.
Simpu PS.
Hmm.
Yes, Your Lordship. Subsequently, we preferred this application and this honorable court was pleased to allow us interim, and accordingly we appeared before the Simpu PS. And I
Okay,
have
what's the interim?
it was on the 4th of March, Lordship. 4th of March, the interim was allowed.
So we'll make it absolute.
Yes.
And on
Yes, yes.
9th of March, we appeared before the IO. IO asked us to deposit the security amount of rupees 25,000, which we could not deposit the same. And subsequently, we deposited the amount on 24th of May. And thereafter, the police official, concerned police official is in touch with us over phone. And we appeared twice or thrice before the IO. And we are all still ready to cooperate with the investigation.
Okay, yes.
And this is the bank details Your Lordship may see. We have deposited the.
Yes, so we
Sure,
will
yeah.
make the interim bail absolute, isn't it?
Yes.
Heard Mr. Heard Mr. T.
Bharali, Lordship.
Bharali, learned counsel for
T.
the
Bharali.
petitioner, along with Ms. T. Jenny, learned additional PP for the state respondents. Today is fixed for hearing of the application made under 438 of the CRPC for granting of pre-arrest bail to the petitioner. In connection with Chimpu PS case number 13/2024, registered under section 120B/419/420/471/379/34 IPC. The learned counsel for the petitioner submits that the petitioner has been fully cooperating with the investigation of the case, and that the interim bail granted to him by this court on 04/03/2024 may be made absolute. So, Ms. T. Jenny, learned additional PP, submits that they have no objection to the prayer made by the learned counsel for the petitioner, since it is seen that the petitioner has been fully cooperating with the respondents during the investigation of the case. In view of the above, this court find it fit to grant interim bail to the petitioner. To grant interim bail, no, to grant bail to the pre-arrest bail to the petitioner with a bail bond as imposed by this court by its order dated 04/03/2024. Accordingly, the instant AB/28 within brackets AP/2024 stands allowed and disposed of.
In reference to the CD, I have produced, maybe written back, you know.
Okay, the CD is to be returned to the concerned. Yes,
My lord, this is Wales application in connection with Naharlagan PS case, NDPS case, of 55. Naharlagan PS case 55, 2024, registered under section 21B, 25, 27, and 29. My lord, in my case is my lord is of section 25 only. But I have been alleged with I have allowed my home for selling of contraband substance. And my lord's FIR is in page 14. Page 17.
what,
And
FIR is in page?
Page 17.
17.
117. Annexure.
Give me the NDPS Act. NDPS Act. Yes, go ahead.
May I?
Oh,
I'll start from straightly from para 1, Your Honor.
hmm.
On dated, my lord, this is maybe read as typing mistakes. Not second, this should be read as 22nd.
Hmm.
There's so and so date at around so and so. A verbal information was received from the reliable sources that one person, namely so and so, is in possession of heroin and is selling it off from the resident of one so and so. This is
So from your residence?
yes.
Hmm.
In Delhi market near helipad, Naharlagan. The sources further state that if not apprehended at earliest, he might flee after disposing of the heroin. The said message was conveyed in writing and entered into the general diary. After that, SP Capital and SDPO Naharlagan were conveyed about the same and they gave verbal approval to conduct the said. The further SP Capital was also intimated to write a written message as well. Accordingly, a team led by undersigned left for the said spot along with the seizure, packing, weighting, and sealing items as mandated by NDPS Act section, accompanied by ESC Naharlagan. Hello. Sri Koda, so and so. Para 2. The team led by undersigned by ESC Naharlan arrived at house located in Delhi Market near helipad as shown by sources so and so hours and around the said house and asked to open the door. When we enter after our personal search is being carried out, the room of said Sri so and so was knocked and he opened the door. He was asked to come out of room and after he came out, they were informed that the police team suspect that he is in possession of drugs, need to be searched and the house. They were also informed that they have the right to search in front of gazetted officer, but they refused to avail the right. Prior to the personal search team, searched ourselves in presence of witness and nothing adverse was found on ourselves. Upon being entered, we found 3 girls, namely so and so, both addicted youth, and a male named so and so, who is the owner of the house. All of them have been placed in a corner of the room, separating the male person, and conducted search operation. During house search, 17 vials, plastic vials containing suspected contraband heroin, weighing 25 grams. That's intermediate one, not commercial, just higher than smaller quantity. Inside the bag, light green in color toy, under bracket, as used syringe, a soap case PR rupees 3,510 rupees recovered and seized according in presence of executive magistrate. The said bag was kept in the mosquito net. Later, it was confirmed that the bag belongs to Miss so and so.
So where are
Was
you
brought to
reading from?
recover.
This is
Yes.
what given in the
Yes.
charge sheet has not been filed.
Not
isn't it?
yet.
So all these facts that you're reading
This is
in the application,
yes.
is that highlighted somewhere?
Yes, Your Honor. My lord.
Where? You're reading from your
FIR.
application or the FIR?
This is FIR, my lord.
Okay.
When my lord, the fact of the case, it will just this is part of the prosecution. My lord, my case is that the alleged accused, namely Anuriba. Your Honor, I know Golo Kuku, whom Golo Kuku and Telinemi, the name girl, they, Your Honor, asked me for a shelter for some days. I was working there at Naharlagan as a security guard, private security guard. So I sheltered them for 2 days. Then during that 2 days, on 20th, the Anuriba, from whom this heroin, the alleged heroin, has been recovered.
Okay, nothing was seized from your possession?
No, nothing.
Okay. Huh.
And they
But they were in your house?
yes.
But they were in your house, these 2 persons from whom the contraband substance was seized, they were in your house, is it?
Yes.
They were in your house?
They were in my house, but I didn't know they are having this contraband substance. Just I give shelter to them only on request of both the girl which police has let off.
Okay, 2 girls.
2 girls. Police. I know that 2 girls. So on that 2 girls told me that this the Anuriba, the alleged accused, the main accused, is the friend. So let her allow to stay in my home for few days. So I allow. On suddenly 22nd of May, the police suddenly came. When
They arrested the 2 girls and you?
Yes.
And who else?
Yes, but later they let off the 2 girls. I was arrested on just the mere allegation that I have this one allow that main accused person.
Okay, so you're the main accused person?
No, I am not main accused person.
Okay.
Miss Anurup. My this one my lord, my only the police arrested me on the ground that the Anurup was staying in my home.
The main accused?
Yes, main accused.
Was staying in your house?
Yeah, my home.
Okay.
So that I allow that main accused on request of both the girl only. That police whom the police let off.
Okay.
So I didn't know whether these girls are addicted or whether they are selling drugs.
Okay, any statements recorded under 161 concerning those what you are stating?
Yes, Your Lordship. I have received the case there, Your Lordship. Before going into the merit, Your Lordship, with all fairness, I would like to apprise this court that today is the 63rd day under the custody and charge sheet has not been filed. So
Then he should pray for default bail.
No, actually, my lord, when I was filing this default bail was not there.
Okay,
So
okay.
why I am my lord, why I am submitting? So If you understand the case,
Charge sheet not filed,
that's why,
60 days over, 167.
yes.
Sir,
in
and
the-
then offense punishable is extended to 10 years. But so far as
Ah.
Rakesh Kumar whole case is concerned, minimum should be 10 years.
Ah.
So 60 days, not 90 days.
60
Your Lordship.
days.
And now today is 63 days running. Your Lordship. So he's entitled for indefeasible right, default bail.
Yes, my lord,
Yes, okay, we'll grant bail
Yes, Your Lordship.
with a bail bond of, I'll pass the order later, okay, with a bail bond of rupees 20,000 and one reliable surety
my,
of the like
my
amount.
lord, may I?
What?
I'm just a
Poor
private
person.
employee. This
Ah.
bail bond would be. Yes.
So you don't have to deposit the bond, it is just a bail bond.
Yes.
So if you don't run away or if you appear, then you don't have to pay any money anyways.
Yes.
Okay. With a bail bond of rupees 20,000 and one surety of the like amount.
Yes.
Who shall be to the satisfaction of the learned. Charge sheet has not been submitted.
Charge sheet not valid before the IO, Your Lordship.
Of the yes, no, it will still be the court. Okay, learned court, okay, and the NDPS Act, yes. We'll dispose of, I'll pass the order later. Okay,
Oblige, Your
civil
Lordship.
matter.
Your Lordship, if
Default
CD required,
bail under 167.
CD, Your Lordship, not required.
No, they will record your submission.
Yes,
that-
Your Lordship.
Okay.
Yes, investigation is clearly reflected here, Your Lordship. Charge sheet not filed.
Hmm,
So
no
now
problem.
today is 63rd day,
So
62
we'll
already
record the
completed.
Submission and default bail will be
Yes, Your
granted.
Lordship, yes.
Yes, in
Oblige,
all
DP.
cases, yeah, next.
But I'm sorry, my lord, office note indicates, my lord, we have to take steps upon a respondent number 2. My lord, may grant me 2 days, my lord, I will take steps.
Okay, heard Mr. D. Ponging, learned counsel for the appellant who submits that they will be allowed to take steps upon respondent. Who submits that we will be taking steps upon respondent number 2 within 2 days. See, previous date also you were granted 3 days time.
I'm sorry, my lord, I just noticed, my lord.
Okay, within 2 days. In view of the above, list after 1 week.
Oblige.
And for
No,
the
but
state
if you
lawsuit.
take steps also, it will still take time. So in view of the above, list after 3 weeks.
And for the state lawsuit.
Okay, the presence of Ms. So-and-so, learned additional PP is noted.
Okay.
May it please my ladyship. I appear for the respondents in item number 16, my lady.
Yes,
My lady, this is a contempt petition for an order from 2022. The contempt is also from 2022. Correspondingly, I have a writ appeal which was instituted 50 days or 70 days after the order. Admission has been done for that writ appeal, my lady, in January of 2023, and arguments were addressed on 3 successive dates in October, very substantially on my part. Unfortunately, the respondents were in some sort of personal difficulty in October 23, so the arguments could not be concluded, and the matter was released from part heard by the Honorable Bench. Now, ever since that matter has not come up for listing, and a quietus to this issue can only be achieved when the writ appeal is decided, my lady, before we get booked for contempt or whether we can show obedience or disobedience. My only difficulty is that once I am an appellant in the writ appellate court and I have taken all due process to ensure that I argue this matter in a timely fashion, only on account of administrative difficulties.
yes. Now, it is noted that you have been absent
My lady, on the last
in
occasion,
the
the learned
previous
ASG,
4 dates, isn't it?
the learned ASG was leading us, my lady. As a matter of fact, today's date was fixed at her request because she was traveling for United Nations conference on behalf of the Union of India.
Whatever.
Unfortunately, she could not be here today, but she instructed me to argue the matter and address my leadership on this limited issue, that the contempt right now is not ripe for hearing only on account of the fact that my writ appeal is yet not decided.
Now, is there a stay concerning the
There is
pending
an application for
contempt?
stay, my lady.
There's
If
no
my
stay.
learned friend would
Have you
let
made
me,
an application for stay of the contempt before the,
That was made, my lord, it was not considered.
My
It
lady,
was
there
not
was a
considered?
stay for the order, an application for stay of the order. And my lady, now there is a interesting aspect as to why this application has also not been heard. There are 386 respondents, my lady, corresponding to the 385 petitioners. Now, service upon all of these people has taken a very long time.
No, that's incorrect, my lord. You're making
no,
a
no,
wrong
no.
submission.
No, no,
You did
no.
not appear on the earlier occasion, Miss Dr. Kothari was appearing. I have been present from the first day itself and I'm appearing for all the respondents. That's incorrect submission.
My lady,
So
today,
anyways, this is a contempt petition for non-compliance of the
Single bench is all. Single bench is all.
judgment of the single bench. Now, you're saying that you have preferred an appeal against the judgment of the learned single bench, isn't it?
Please,
Which
my
is still
lady.
pending before the division bench.
Please, my lady,
Now,
which stands admitted. Which stands admitted and is pending, my lady.
okay, when is the next date fixed then?
There is no next
In
date
the-
fixed, my lady.
Then a time
My lady, the
given.
last order says that it has to be listed within 3 weeks. And
Oh,
unfortunately, it has not come
do
up
you
for
have a
listing.
copy of the last order so that we can see?
My lady,
You should have
co-counsel-
downloaded the copy of the order of the last order,
if my
isn't
co-counsel
it?
could assist.
Huh. Now,
lady,
you are appearing for the respondents, is
Please,
it?
my lady.
You're appearing in your personal capacity or on behalf of your, what the senior whom you have mentioned is out of,
My lady, I'm appearing on behalf of my personal capacity. I'm a panel Group A counsel for the Union of India and the Supreme Court.
okay, so in your personal capacity, is
Yes,
it? Yes, okay. Then, but you're saying that you don't have the copy of the order passed by the division bench wherein the matter has been adjourned for 3 weeks.
My lady, unfortunately, I have a copy here physically, but it appears my co-counsel is not having a copy. If I may read it out, it's just 3 lines.
Yes.
My lady, the order is dated 22nd April 2024.
Okay,
This was
April.
before
Huh.
this was before the bench of Justice Vankung and Justice Goswami, my lords,
Okay, that means before. Okay,
a division bench.
yes.
And here the order reads, Ms. Tanya Agarwal, learned counsel, appears on behalf of the Union of India, while Mr. D. Panging, learned counsel for the respondent, is present. As submitted by the learned counsels, list the matter after 3 weeks. So from April to now, my lady, this date has not been notified.
We will wait for some time then.
I leave it to a contempt between the honorable court and unless contemptors. I have brought before your lordship that the judgment of the learned single judge has not been complied. But admittedly, the appeal is pending, ma'am.
It's pending. isn't it? Yes, heard Mr. D. Pangin, learned counsel for the petitioner, along with Mr.
Arkaj Kumar, my lady.
Okay, so and so learned counsel for respondents, for the respondents. Is it? Respondents number
1 and 2, my lady.
1 and 2. The learned counsel for the respondents submits that the writ petition it's been appealed against and the writ appeal number
38 of 2022.
38 of 2022 is still yet to be disposed of by the division bench. He phrased that by the order of the division bench dated.
I'm sorry.
The order which you read.
22nd April, my lady, of
22nd
2020.
April 2024, the matter was to be listed again after 3 weeks. However, the matter has not been come up before the division bench till date and is still awaiting disposal. In view of the submissions made, list this matter after 3 weeks. Yes.
Okay.
Obliged, my lady.
Please, your lordship. Lordship, I need some more time to go through the file and then some case laws, lordship.
What,
at least
what
one
the
week.
IE about?
This was condonation of
I
delay.
was in
the
regards
partner.
to condonation.
Okay,
In the last
Okay.
occasion, my
Okay.
colleague friend was representing this case, Lordship.
okay.
And then
Oh,
he has
yes.
handed over the file to me, Lordship. So I
Oh, it
need
was part one, so we'll release it from part
a
one.
Lordship.
Heard Mr.
J. Gini, Lordship.
Learned counsel for the applicant along with Mr.
Devocative
So and so learned counsel for the respondent.
respondents.
The learned counsel for the applicant has prayed for adjournment. In view of the above, this matter is released from part heard and is to be listed again after 2
Can it
weeks.
be on 7 August?
Okay, is to be listed on 7/8/2020.
Oh,
Yes.
lovely. Much.
Your Lordship, as per the office note, they have not taken steps, Your Lordship.
Respondent number 2. This is cases concerning what?
Appeal against Your Lordship, conviction, Your Lordship.
Under section? Why is respondent number 2 necessary? I'm just thinking.
Yes, Your Lordship. On light of the, Your Lordship, Jagdish Kumar matter, Your Lordship, the notice was issued, Your Lordship. Otherwise, in the POXO matter is a clear guidelines regarding implement.
So it's required.
Yes, but
In the others, is it really required? I don't think we're doing it in other benches.
in other cases, Your Lordship, it says they have a participatory right, unbridled
No,
participatory right.
issue notice.
Yes, Your
And if
Lordship.
they don't appear, it's not required.
Yes, they have not taken steps and no, Your Lordship, the service has not been completed. If service is completed, then in that case, Your Lordship,
No.
the court can
See,
proceed further. Your Lordship.
even if issue notice
Yes.
and we await for return of the AD,
Yes, Your Lordship.
maybe for 1 month, 2 months, then we don't have to keep the matter pending. Okay, it's not very necessary that service has to be completed. Okay,
Your-
but they have notice, okay, can be issued. But here you have to take steps which you have not taken yet. So heard Mr. So and so learned counsel for the appellant along with Mr. So and so learned additional PP for the state respondents. The learned counsel for the appellant has prayed for time for taking fresh steps upon respondent number 2. In view of the above, fresh steps are to be taken lest after
3 weeks, Your Lordship.
3 weeks.
Oblige, Your Lordship.
Fresh steps are to be taken upon respondent number 2. Yes.
Oblige.
Yeah, my lord. My lord, here we have filed one IA impleting all the victims' party respondent. And we have taken the steps, but due to some reason, the steps could not be completed. Therefore, my lord,
The appeal
We may
is. Wait. No, what is going on? Let me just see. Okay, this is an application made under 482.
yes, ma'am.
Now in the IA, it was allowed, is it?
Yes, ma'am. My lord, we may be allowed to take fresh.
Okay, the learned, heard Miss
G. Basar,
appearing on behalf of her senior Mr.
T. Sunil,
to the learned counsel for the applicant slash petitioner who has prayed for further time for taking steps upon the respondents. In view of the above, list after
2 weeks.
2 weeks.
Much obliged.
Yes.
May I please, my lord?
Finally, here in the matter, I represent on behalf of private respondent number 7, 8, 9, and 10. And I have already filed affidavit in oppositions for respondent number 7, 8, and 10. So this morning I filed Wakalatnama on behalf of respondent number 9. So I
Okay.
may need time to file affidavit.
Yes, yes. Mr. So-and-so, learned counsel for the petitioner is present along with Mr.
N. Rama.
And Rama, learned counsel for respondents number 7, 8, and 10.
Yes, my
Is that-
already filed 7, 8, and 10.
The learned counsel for respondent number 7, 8, and 10 submits that he has filed his wakalatnama for respondent number 9 and prayed for time to file the affidavit in counter affidavit. Yes. Ms. So-and-so, learned government advocate is present. Okay, no, learned government advocate submits that
We have filed for respondent number 1, 2, 4.
they have already filed the counter affidavits.
And we will be filing for respondent number 3 and 5.
File the counter affidavits for respondents number
1, 2, 4, and 6.
1, 2, 4, and 6, and paid for time for filing of their counter affidavits for respondents number
3 and 6.
3 and
3 and
6. 3 and 5. In view of the above, list the matter of the 3 weeks on a date fixed by the registry. Yes.
Highly organized.
Yes.
Lordship, this is a joint application under Port 82 of CRPC. Lordship. For quashing of FIR dated 10/9/2019 and all the consequential criminal proceedings thereof. Lordship, may I take you to the FIR, Lordship? Is that
Yes.
page number
The
24?
FIR.
Page number 24, Lordship. 5 copies.
Yes.
My Lordship.
Hmm.
With due respect, we UAIF PF would like to lodge an FIR against Mr. So-and-so for conducting undemocratic and unlawful activities on 9/10/2019 in Naharlagan market. They have forcefully shut down the market without proper intimation to the concerned authority. They were also using certain unparliamentary words and tried to create communal disharmony in our peaceful state. They've also threatened to give economic blockade to our people. We are with the Brip family, no doubt, but we will not hesitate to react when it comes to our dignity and honor. So with the UAIPF, kindly request you to arrest Mr. So-and-so as early as possible and book him under proper section law. This is the Lordship FIR.
Hmm.
Lordship, brief fact of the case is that on 10/10/2019, Lordship, at 11:45 hours, a written FIR was received from the present petitioner number 2 and 3 against the petition number 1, as alleged in the FIR. Accordingly, the Naharlagan police has registered a case and as recorded as a PS case number 170 of 19 under section 153, 153A, 506, and 34 of IPC laws. Lordship, after the filing of charge sheet, Lordship, the petitioner 1 and petitioner 2 and 3, the instant complainant in the FIR, has arrived in the mutual settlement. And now they have decided not to pursue the case further. So accordingly, they have filed and come before this honorable court and filed this joint application. So Lordship,
Okay, case was registered against them under section
153, 153A, 506, and 34.
give me the IPC.
One 153 is wrongful giving provocation with intent to cause not if writing be committed, if
Yes.
not committed. And punishment is extended up to 6 years.
Up to
152
how much? I want to see the sentence part. Sentences up to?
6 years,
Oh,
extended up to 6. Oh, no, 6 months, Lordship, not 6 years.
months.
Yes.
Oh, yes.
And 153A is,
A is,
yes, promoting enmity between
yes.
the different groups.
This punishment may extend up to
3 years.
So these are, okay.
And Lordship 506 was there,
Oh.
Lordship.
Yes. Go on. Then what happened? They were
Lordship,
charged under these
Yes.
sections.
charge is already framed, Lordship,
Hmm.
by the court below, Lordship. And this 506, section 506 has been
Has been dropped.
Yes.
Okay. Yes.
Now only 153 and 153A
Hmm.
is charged against
Okay.
the eligible petitioner, Lordship.
Oh.
So, Lordship, since the informant 1 and 2 has already agreed and come into the settlement,
Where's the settlement? Is there any document
Yeah.
before that they have come to a settlement?
page number 41, Lordship.
Okay. Compromise settlement deed. Signed by?
Signed by petitioner number 1, that is eligible person,
Hmm.
petitioner number 2 and 3, that is informant.
Okay, the informant.
Yes.
Oh. Yes. APP. Anything to say in this matter?
Lordship, actually, Lordship, this is, they have come under the 482 Lordship during the settlement. And Lordship, last occasion, the Lord's Honorable Court has, they want to see whether the other, these parties are willing to settle this matter amicably or not, Lordship. That's why they have filed one IA in this regard. So the other executive members also participated.
Who is the IA? In this,
Additional affidavit, Lordship, informed.
what?
Yes.
So come, tell me what's going on, finish.
Yes,
your
Lordship,
things.
this is additional affidavit. While during the course of hearing, this honorable court has observed that the rest of the executive members need to file affidavit.
Okay,
So I have filed.
continue, tell me
Yes.
what's going on,
Yes.
Bits and pieces you're telling me, So you filed the additional affidavit.
Yes,
is
Lordship.
it? So
Page
what
number
does
5
the
of-
additional affidavit say?
Page number 5, Lordship. This is the minute of meeting. Basically, Lordship, this petitioner number 2 and 3 were the president and general secretary of all Arunachal Indigenous Peoples Forum, Lordship.
Okay,
The FIR was lodged under the banner of the forum. This was-
okay, so you have filed an additional affidavit showing the
yeah, so in,
minutes of the meeting,
yes,
is it?
rest of the
Dated-
executive members, they don't have any objection.
Yes. Okay, so this is dated 25/02/2024.
Yes, Lordship.
What is the contents of the minute?
My Lordship.
Hmm.
The central executive members of United Arunachal Indigenous Peoples Forum had convened a meeting under the chairmanship of so and so on 25/2/2024 to discuss the matter related to the criminal case in matter of State of Arunachal Pradesh versus arising out of Naharlagan PS case 170 of 19 under section 153, 153A, 1506, 34 of IPC, for which the police has charge sheeted the case and submitted before the court of Chief Judicial Magistrate White number 62 of 2023, dated 028/2023. During the meeting, the members have decided that the executive members of United Arunachal Indigenous Peoples Forum have no objection to Sri so and so, that is petitioner number 2 and 3, in entering into the compromise settlement deed of agreement aforesaid criminal case with Sri so and so, while considering the peaceful coexistence of different communities in the twin capital city as well as state of Arunachal Pradesh. Further, the members have agreed and decided to share and file separate affidavit before Honorable Court in support of pleading taken by Sri so and so, in a joint criminal petition number 25 of 2023 for quashing of FIR charge sheet and subsequent criminal proceedings.
So members present, all of them are
Yes,
present,
Lord.
is it? How many people?
There
are
is
there?
26 members, total
Oh.
26 members, and they all were.
26 members.
Yes.
Yes. So
Well, Lordship,
we'll allow.
Lordship is a discretion of this court, Lordship.
Yes.
Because
Third,
they have,
Mr. So-and-so, learned counsel for the petitioner, who has filed this application under section 482 of the Criminal Procedure Code, 1973, for setting aside and quashing the FIR/charge sheet/criminal proceedings against the petitioner in GR number 707/2019, arising out of NLG-PS case number 170/19 under section 153/153A, capital A, okay, /506/34 IPC.
Lordship, may Lordship, during the order is maybe reflected that it is quasi Lordship, but this certain this petitioners Lordship, applicants Lordship, they may not be Lordship participated in the future Lordship in this kind of Lordship.
Okay. The learned counsel for the petitioner submits that the petitioner and the informant who had filed the FIR have now come to an amicable settlement.
The person to be for whom the FIR has been registered Lordship, the applicant
The
Lordship,
petitioner.
applicant Lordship. He may not be participated Lordship in this kind of Lordship.
Please effort what you
Yes,
said. And that have come to an amicable settlement by executing a compromise/settlement deed dated dated what?
21
21st
21 February
21st
2024.
February 2024. Before the notary public, Itanagar, Itanagar, wherein it was mentioned that in view of the compromise arrived between the parties, the entire differences and grievances arising in between the parties stand resolved, and the parties shall maintain social harmony, brotherhood, and peaceful atmosphere amongst each other. Full stop. The learned counsel further submits that in the additional affidavit filed subsequently, it is also seen in the minutes of the meeting dated 25/02/2024 that the petitioner / accused is representing the United Arunachal Indigenous Peoples Forum within brackets, UAIPF. And all the members.
Lordship, may Lordship, the applicant Lordship is not representing, the Lordship complainant is representing Lordship. United Arunachal, the complainant Lordship.
Okay, not the petitioner.
No, Lordship. Petitioner Lordship,
Okay.
he is
And
the,
that
against
the,
whom the FIR has been lodged, Lordship.
Informant. Okay. / complainant.
And Lordship, the
Yes,
FIR has been lodged,
representing
not because
United
Lordship,
so-and-so.
between this Lordship, Lordship, the issue is not between them, Lordship. Actually, the issue is not Lordship, this petitioner Lordship, the accused Lordship. Yes, Lordship, some unlawful activities which they have been Lordship for the public at my last Lordship. For their debt statement, Lordship, it is Lordship, FIR Lordship, Lordship, because Lordship, the accused Lordship,
I'm not understanding you, but see, they have
Lordship.
filed as minutes of the meeting, isn't it? Where he's representing this organization.
No, Lordship, representing organization by the Lordship,
Minutes
the
of the
complainant
meeting.
Lordship. The complainant Lordship, Lordship.
Yes, the complainant is representing this, isn't it?
Lordship.
Huh.
And the accused Lordship, the petitioner Lordship, he is the
So
one.
we've made the change,
Lordship.
complainant, isn't it?
Lordship.
So and so, minutes of the meeting, so and so. Yes. Wherein the complainants slash informant. As per the compromise slash settlement deed. Instead of parent, it shows, okay, is willing to withdraw the instant FIR. And it is mentioned in the agreement that steps will be taken for the subsequent criminal proceedings to be cancelled or quashed from the court, appropriate forum or court. Miss so and so, learned additional PP submits that in view of the compromise deed executed by the informant and the accused, this court, she leaves the matter to the decision of the court.
Lordship, that the accused Lordship, the petitioners should not be Lordship, indulged Lordship.
She always submits that a condition may, however, be imposed that the accused slash
Petitioner.
should not indulge in any sort of activities in future.
Lordship.
Having heard the submissions made by the learned counsels for both the parties, this court finding that the parties have come to a compromise, find it fit to invoke its powers under section 482 CRPC and quash the further proceedings of the case. Yes, what is the case?
Yes, case number 170 of 2020.
Yes, PS case number 170/19 under section 153/153A/506/34 of the IPC.
Pending before CGM.
Pending before the
CGM UPR.
learned CGM UPR.
Yeah.
Accordingly,
Recorded as GR
petition
case.
number 25 AP of 2024 stands allowed and disposed. Yes.
Obliged, Lordship.
Yes, I think we'll.
My lord, this is also the similar nature with this, my lord, the
Ah.
item number 23. This is the, 22. This is the application, my lord, filed by both the petitioner as a accused person and my lord, the informant. Here in this case, my lord, the under
But the
482,
sections are different, 307,
my lord.
341,
There
506,
is
slightly
a
more serious of
incorporation of the 307. So, my lord, I'll take the lordship, pertaining to the Chimpu PS case number 47 of 2022 under section 307, 341 and 506 IPC. My lord, may kindly come to the page number 22 is the FIR.
Hmm.
My lord, page 20. My lord, this should be page number, sorry, my lord, 14, 14.
1-4.
Yes, about copy is 14. Despite the original copy annex is annexure and 14 is the FIR. FIR report says against such and such, alleging the commission of the open punishable under section such and such. Respected sir, with proper agony in undersigned, instead deploying FIR before you and its collection. The above name Alice accused person is residing in the Ganga place. Son of such and such, mobile number such and such, that on 29 September 2022 at around 1 p.m. he had attempted to kill the undersigned with his sharp message down at Ganga place. The alleged accused person has suddenly struck off the necks of the undersigned. Fortunately, the victim could have moved away from cut away his neck. Somehow he managed, and the accused person had managed to cut off his face with the dowel, whereby the undersigned sustained a grievous injury on his face. Thereafter, the alleged accused person has attempted further several rounds, but one of the Techilakam of the bird bless has prevented the alleged accused person from the next attack. If Techilakam would not have been there, the accused person may be killed in the undersigned certainly. After the said incident, the undersigned was rushed to the RK hospital, Itanagar, whereby he got more than 15 stitches and presently undergoing treatment. Hence, in the light of the facts and the circumstances above, the undersigned pray you to be authority to immediate arrest of the alleged accused person and the commission of the offense, attempt to murder and the criminal conspiracy, voluntary causing hurt by the dangerous weapon and the criminal intimidation there. So, so far the contention of the FIR is very serious that I am. But in due course of the investigation was conducted and thereby the FIR charge sheet was filed. And I will take the lordship to the charge sheet, whereby the charge sheet revealed that whatever the injury was simple in nature. My lord may kindly come to the page number 22. It is start from, I will take to the relevant portion only, that page number 22 in the first para, if we, before come to the conclusion, if it is counted from the bottom, it is in the 7th line. The MLC report of the victim person was collected from the RK mission, wherein the doctor opined that the cut marks of the victim is 7 inches in the length and 1 inch in depth of the face, and the nature of injury is minor on the left side of the face, and also the another minor injury in the thumb's right of the right hand. In the nutshell of the doctor opinion, the simple injury on the part of the victim, and there might have been a fatal injury on the part of the victim as well as their consequence. So, my lord, in total,
But 307 is still there.
my lord,
Attempt to kill.
307 is still there.
With an
So,
abrupt-
my lord, despite of this, both the party has come to settle, and accordingly, both the party has settled the matter amicably before the outside of the court. In this connection, lordship may kindly come to the page number 24, and the operating portion of their amicable settlement is on page number 25. My lord got it? Page 25. This deed of the mutual agreement is made without the coercion of any parties, whereby the first party and the second party have decided to settle the matter amicably to avoid the further proceeding of the court. On being requested by the first party and the intimation of the elderly peoples of the parties to the instant case as mediator, the second party accepted to the settled case with the mutual understanding. Both the parties are the close relatives. Each
How are
other.
they related?
My lord?
How are they related?
My lord, they are related, since they belong from the my lord, the same, they happen to be my lord, they causing each other. Thereafter, my lord, in the covenant whereof both the parties accepted that The said incident was very much unfortunate. This, my lord, may kindly noted. 3. Both the parties accepted that the said incident was very much unfortunate and under the influence of the alcohol, and as such, the mutual settlement is made within the family members of both the parties to maintain the peace and tranquility in all days to come. That after execution of this mutual agreement, the matter shall be treated as a clause, and as such, both the parties shall pursue to the case by the Chimpu PS case number such and such, corresponding to the session case number 32 for quashing before the appropriate forum, and the second party shall fully cooperate to the first party in the due course of the legal proceeding. So this is what they have concluded. Now, my lord, the substantial question from this lordship is whether the FIR, whether in the PS case, where there is an incorporation of the 307 can be settled and in the form of, whether this can be quashed in the form of 482. So I have answered before the lordship. This is the cover-up case, my lord. In fact, in connection with the Narendra case as well as the Lakshmi Narayan, in continuation to that, in collaboration with both the case, Kapil Gupta versus State of the NCT of the Delhi, this reported, and accordingly this court has quashed the similar nature of case in view of this in the criminal petition number 168 of the Parliament. So lordship may kindly peruse the 13 and para 13 and 14. This is the case wherein even 341, 327 and the 326 grievous injury was also there in addition to the 307, but this has been quashed by this honorable court. Whereas in the present case before the lordship is involved
Okay, this was
with
307,
307.
427 and 307. Okay. Yes.
So
Read.
without wasting much time, my prayer before this honorable court, this need to be quashed in view of this judgment cover under the this cover under the Supreme Court. The case already decided in the Supreme Court.
The coordinate bench of this court. Yes. Yes. Anything else?
So far the stage of the trial is in the initial stage.
Yes. It's lunch break, but we'll finish up this matter at least. Yes. What are your objections? We have cited this decision of the division bench of this court, where the compromise between the parties, where the petitioner was charged under 307, 326, etc., was accepted.
If the
Same.
injury is not lordship, grievous lordship.
Indulge in similar offense in future. Same.
Lordship, and this is their related their lordship. Lordship, I have only one point is to hear lordship, but they think to lordship may be considered lordship.
Okay, we'll allow, but it's lunch break. So now, besides this, there is one more case, is it? Allowed, disposed. I'll pass the order later because it's lunch break. Okay. Now, there are 2 cases left. 3. Okay, then we'll have to sit again after 2.
Actually, lordship, this case, lordship, this Elsa record was called for, but it was not their lordship. Although lordship, it can be lordship.
It will be
Record, yes.
disposed of.
Lordship.
Okay, allowed and disposed.
Lordship, in earlier occasion, I was directed to take a step upon the respondent, sole respondent, and but I could not take a step as for the procedure. So but I have taken the step.
You need further time.
Yeah, I need
Okay.
some more time to take a
Miss
fresh step.
The Rilung,
The Rilung, yes.
learned counsel for the applicant has prayed for further time for taking steps upon respondent. How many respondents?
Only one.
Upon the
Sole
sole
respondent. Through registered
Yes,
with
has
ID.
steps up through, yes. Has prayed for time for taking steps upon the sole respondents. In view of the above, this after 3 weeks.
Yes.
My lordship. As per order dated on 25/6/2024, the applicant has been directed to take dusty service upon the respondent number 3. And on the basis of that, we have taken the.
So you filed the affidavit
Yes, we have.
showing
filed
that
the-
you're taking steps.
we have already filed it and the extra copy is here with me. Here.
Okay, it's here.
Yes.
Affidavit to the
Yeah.
effect, yes.
And. Record is there. Okay. Then, on the basis of the order dated on the 25/6/2024, the interim prayer of the petitioner shall be considered on the next returnable date.
You should have given this to the registry, isn't it? Now, where's the? Let me see.
Your Lordship, we have received the
You
Paravis comment.
received a copy. And you're giving it to us now, to the court now, is it?
No, my lord, affidavit has been filed in the record.
Okay, to the
registry.
registry,
And this is my extra copy.
Yes, so. No, extra copy is not required because I think the registry just now
Yes.
handed me the affidavit of dusty service.
No, I think it is in the record.
Annexure 14 and Annexure 15, yes.
It has already been placed in the record. See.
Anyways, Yes, so anyone appearing for respondent number 3?
No. Okay, I'll be repeating.
Okay.
All the responses.
So you'll have to file your counter,
No.
isn't it?
No, today my what called this interim may be considered.
Even extra copies have not been served to us. Miss.
Yes, you serve copies to the councils, isn't it?
No, extra copies also served. Extra copies also served.
Who is respondent number 3?
Extra copy has been served with the company. Anyway, we may be given some more time.
Yes.
Lordship, I'll be representing for respondent number 1 and 3, Lordship.
Heard Mr. So-and-so, learned counsel for the petitioner. It is seen that notice about respondent number 3 has been served through Dusty and affidavit to that effect is accordingly filed. In view of the above, notice upon respondent number 3 is deemed to be complete. Mr. So-and-so, learned counsel submits that. Who is respondent number 3?
3, Lordship, I'm
Inquiry officer.
inquiry officer.
Okay, submits that he will be representing respondents number 1 and 3. Then, who is 2?
To his secretary Lane Lordship, Mr. Kamduk is standing counsel for the department.
Okay. None appeared for respondent number 2. Requisite copies already received? Requisite copies of the writ petition to be duly furnished to the learned counsels for the respondents, if not already done. Okay. List after 3 weeks.
No, my lord.
What?
Here in the case is the matter is
Urgent.
I have already retired, but the departmental proceeding is continuing against me, the disciplinary action. So after retirement, whether it will be continue or not, that is the problem. So unless it is interim prayer is considered, then
what is the interim prayer? Is it there in your?
Interim prayer means the departmental proceeding should be
Where?
kept open. In the interim, pending disposal of the Eastern petition, the order dated on 6/6/2024 and further proceeding of departmental inquiry against the petitioner may be suspended till final disposal of the writ petition. That is my prayer for the interim. Because I have already retired on 31st May. But the departmental proceeding is continuing even in the month of June.
Okay, so in your case, a departmental proceeding was initiated against you, is it? What? Give me the facts of the case. You all know your case, but, so, yes, present your case. Give me the facts of the case. Why are you praying for interim order? Yes, tell me, what is your case?
Now, what is exact my
You were appointed as what? You are a government servant?
Yeah, I was a government servant. I was served as a director of land management.
Okay.
Then I retired on 31st May 2024.
Okay, you've already retired, then?
Yes, and there was during my service tenure, there was a departmental inquiry. Departmental inquiry that is in page. A departmental memorandum of article was initiated. That is Annexure 1, page 21. This is the memorandum of charges. Then after this, a inquiry officer was appointed. The inquiry officer was appointed. That is page 49. Page 49. This is type out copy. Now, therefore, the undersigned in exercise of the power conferred by sub-rule 2 of the said rule hereby appoints Sri Ajay Kumar Dixit, IS Secretary Labor and Employment, Government of Arunachal Pradesh as the inquiry officer to inquire into the charges framed against the said Sri Inyo former director. Now, on the basis of that, the departmental inquiry after appointment of it was initiated. Then, from the date of appointment, that is 14 June 2022, the departmental inquiry was initiated. It was to be completed within 6 months. Now, 1.5 years gone. After 1 year, 4 months, again, he was transferred out. After 1 year, 4 months. Then, she in Longpai, that is page 50, Annexure 7. Longpai was appointed as an inquiry officer. Now, from the date of appointment, that is on 4th September 2023, Longpai, the inquiry will not counted from the date of his appointment, but it will be counted from the day of the first appointment of the first inquiry officer. Longpai is the second inquiry officer. Now, As per this appointment order, this is Annex 7, page 50. He should submit the inquiry report. He has been appointed after 1 year, 4 months. And from the date of appointment of second inquiry officer, he should submit the inquiry report in the month of March, within the 6 months. Now, what 6 months? But they have not done it. Now, come to the para 19 of my writ petition. Para 19, that is page 13. Page 13. That the CCS Rule 1965 prescribes 6-month time period for completion of departmental inquiry after date of appointment of inquiry officer. And the inquiry authority may record the reason and seek extension of time from the disciplinary authority.
So 6 months time. So when was the last appointment of the inquiry officer? March. You're saying March.
No,
When was the inquiry officer appointed?
last inquiry officer appointed is on 4th September 2023. That is page 50. This is
Yes. So
second-
6 months have already lapsed. 6 months is over. So
Then they have not sought for further extension of time. When they sought for further extension of time, they should give the reason on what term it has been delayed, or on what term it has not been completed.
no, so
in 6
no,
months.
let's see now. Time is already expired. 6 months is over. Nothing is there.
And that is the thing. That is and
That's why you have filed your writ petition.
no, no. And annex page 13, page 60, page 60. Come to the page 60. That is one of the interim order which I have challenged.
Yes.
Now, the proceeding were taken up. The proceeding were taken up by me.
This is
in my
2022.
yes, the 26/6/24. That is after my retirement. After my retirement, at 1200 hours in the proceeding, Sri K. and Damo, presenting officer, director, tourist was present. However, Sri Enyo Nanka, search officer,
See, memorandum of charge is dated 04/02/2022. And now what is happening? What is the present status concerning the departmental inquiry? What is going on?
The two after I retired. How did the departmental inquiry continue after my?
Okay, so there's an order. You have not come to this. There's an order dated 06/06/2024.
Yes.
What is that? Let's see that order.
06/06.
The present time.
In the proceeding, Sri K. and Damo, presenting officer, director, Torio was present. However, Sri Enyo Nanka, search officer.
Where is that order? 06/06/2024. Take me to that order.
Page 6, page 6.
Page 60. Page 60.
Okay, so you want the suspension of this, interim suspension of this order?
Yes.
Okay,
Lordship,
it's as simple as that,
permanent proceeding is going on.
huh?
The question in the present writ petition is whether after retirement, the
Hmm.
departmental proceeding which was initiated before retirement,
Hmm.
whether it can travel after
Yes, continue,
retirement or not.
yes, yes.
The law is very clear, Lord. Honorable Supreme Court, even it can be disposed of by dismissing it. Law is very clear, Lord. If I take laws ruling, pencil rules, laws. Just I'll read laws.
Yes,
what it
after
says, Lord.
pension.
The departmental proceeding referred to in sub-rule 1, if the instituted while the government service government servant was in service, whether before his retirement or during his re-employment, shall after the final retirement of the government servant be deemed to be proceeding under this rule, and shall be continued and concluded by authority by which they were commenced, in the manner as if the government servant had continued in the service. It's very clear, Lord.
But what is his prayer? What is his main prayer in the?
He's setting aside of the entire proceeding, Lord.
Because he had this thing. Because you're already retired.
Retired.
That's his submission.
Retired. And as per, so as per Rule 14, Sub Rule 24, they have not complied. They should submit the
No, but his ground is something else. It's not only because he had retired. He's saying that after the appointment of the inquiry officer, okay, the inquiry officer appointment is up to 6 months. He has to submit his report, which he failed to do. So that I think is one of his grounds which you'll have to look into. It's not only saying that it is because after his retirement. I think that's his point.
Lawsuit, yes, nothing on the lawsuit records or law lawsuit.
So
If
that
suppose
will,
it is not submitted within 6 months, does it mean that lawsuit, that proceeding will lapse lawsuit?
That's his point. That's his point. That is one of the points.
Yeah, that's one of
Isn't
the
it?
lawsuit permission.
So if you look into that, it is not only that after the retirement it has continued. That is not his point. He's trying to raise this point that 6 months lapse, not reappointed, not completed without within the prescribed 6 months, and therefore he cannot continue.
Yes.
I think that's his point.
Yes, and
Not because he is already retired.
apart from that, they
So
should
let's
show-
see what is his submissions. He might be having something.
Interim officer should make
They will issue
for extension of the period.
Yeah, this is it. When lawsuit, the proceeding lawsuit, almost 80% has been completed. Only 20% has left lawsuit.
So that's why he's fearful that now it's almost completed. Okay, so he's saying that let it be stayed till this thing is heard in the writ petition.
But
his submission is that
Yeah.
unless it is stayed now,
But how?
it is
lawsuit-
almost completed.
But for that lawsuit, there must be a prima facie case lawsuit. If lawsuit kindly come to page, oh, lawsuit instruction has been received lawsuit.
Oh,
Here lawsuit will
instructions,
find 5 March 2024.
Ah.
One.
So you file your this thing. That is instructions received, so you will file your this thing, isn't it? Counter affidavit concerning this.
6 months extension is already granted in the month of March.
So that in your counter affidavit, you're going to counter what he's claiming, isn't it?
Yeah.
So
So
we'll wait
my
some time.
submission is the lawsuit. Prima facie lawsuit, there's no case lawsuit. Therefore, interim may not be lawsuit granted. That's my submission.
Unless interim is considered, I have already retired, and I will be called time to time. I said, have to appear.
He has to pay lawsuit. He has paid to the Departmental proceeding lawsuit. He has committed something wrong. Therefore,
So we'll have to see, isn't it? We'll have to see that. Okay, I heard, what was that? So and so, completed. Okay, for filing of the counter affidavit, is it? Meanwhile, the learned counsel for the petitioner has prayed that the order dated 06/06/2024 which is the proceedings of department inquiry against the petitioner may be stayed till the final disposal of the instant writ petition.
lawsuit, so far this interim, if lawsuit is granting interim lawsuit, how that will benefit the petitioner lawsuit? Because everyone asks lawsuit, we want the expeditious lawsuit completions of the department.
He doesn't want it completed fast. Maybe he has his reasons.
And therefore, I'm just producing before this one of court.
Hmm,
That 6 months period has been extended for further 6 months lawsuit. I'm producing extension order lawsuit.
But when was the extension order? Now we're looking into the main writ petition before.
Because on day one lawsuit, interim was lordship asked for lordship, prayed for. Because it was not granted lordship. Now there's no change of circumstance lordship.
Okay, where is
If-
it?
if
Where is
we-
it? Where is it not granted?
No, that
Previously.
may not be their lordship, but the
Oh.
day one lordship, when this
Was it
rate
prayed
petition
for?
was moved lordship.
Was
Obviously,
it
lordship,
prayed
in
for?
the rate petition, it's prayer is there lordship.
See, because,
Ah,
no, here
interim,
on day one itself, nothing has been mentioned. Only copies. And here it says that interim prayer of the petitioner shall be considered.
yes.
After due
Okay.
service on the respondents. lordship.
Yes,
So
we have
now have you?
Now just we are before this one call lordship. We are yet to file our lordship.
We have served. Filing is different
Notices?
and receiving is different.
Okay, we have been sub lordship. We have.
So I've heard your submission. You have, I've heard your submission.
I'm
Isn't it?
producing the extension order lordship.
Huh? So you're producing the extension order.
Lordship.
Now,
Only his ground is
No.
lordship, because 6 months has left lordship. Yeah, because that has been extended lordship.
No.
That I'm producing.
Counting from 14/6/2022.
Yes, we'll have to. look at the dates.
14/6
Do
to 2023, 1 year.
lordship two.
Now again, 14/6/2024, 1 year. The 2 years,
Lordship,
how it will be
lordship,
continued?
lordship, two issue lordship.
Independently.
Lordship, whether after retirement lordship, whether the proceeding can continue or not. That is settled by.
That is clear, huh?
Apart from whether within 6 months lordship. If that.
So he has given dates. Okay.
You-
Which is
here
the
is
6
also-
months. Yes, so I'm not inclined to, because that will be deciding the writ petition itself straight away. Isn't it?
It is
So,
granted lordship, it will amount to lordship, final lordship.
No.
till the next date,
But
isn't it?
how that will
And
benefit the petitioner lordship?
Then you will file your written counter affidavits. Okay, you will find your counter affidavit in the meantime. And if the matter is as simple as you projected in the court, if pleadings are over, we can have the matter can be disposed of at the
Lordship,
stage of
my-
admission hearing itself.
Then my submission may be recorded.
Yes, you.
I'm producing the lordship, the extension order. lordship.
Yes, okay. Which is so strong, has prayed for so and so, which is strongly objected by the Mr. So and so, learned counsel for respondents number
1 and 3.
1 and 3. Submitting that the extension order for appointment of the inquiry officer is dated
Lordship, the present extension
uh,
dated 5 March 2024.
5 March 2024, and we will file the necessary documents by way of an affidavit in the by the next court date. In view of the above, this court find it fit to pass an interim stay of the order dated that mentioned till the next court date. Okay. Till the next court date,
How that will benefit the petitioner lordship? That's the issue. There's no point
till the
waiting.
next court
Yeah,
date.
unnecessary harassment.
Harassment. Proceeding is going on.
Now,
but-
I am in my native village and I shall have to come twice and thrice for a month.
Anyways, so interim is granted till the next court date. Meanwhile, whatever documents by way of affidavit, and then it can be reopened and considered again. Isn't it? Yes,
After 1 week, lordship.
pardon?
After 1 week.
If
Because our,
you are ready,
we
huh,
have received the instruction.
This matter after 1
1 week.
on a date fixed by the registry. Yes, both of you are in a hurry, huh? Yes.
May I, Lordship?
It's a fixed matter.
Lordship, I, on behalf of the DOCOM, the learned counsel for the petitions,
What?
Your Lordship, we don't have any instruction from our client, so we your all,
You are for the petitioner,
yeah.
and this is, what do you mean you don't have any instructions?
So client, it's a client there. It's according to the client.
You might want to withdraw, what? You have filed the petition because the petitioner told you to file the petition with petition, isn't it?
So Your Lordship, you may
So
order
is
any
there some
necessary order.
instructions that you're required to obtain? Let's see the last order.
They have filed their reply, my lord.
So now,
Pleadings are complete, but this matter will be disposed of. Now, what we are saying, my lord, this writ petition is not maintainable.
oh. So you're the
Since
counsel?
they are,
Who's the leading counsel? You?
he is present, he is in somewhere in the
Yeah,
court.
I'm presenting on behalf of my senior
So
Dokum.
senior is the leading counsel. in
My lord,
this
senior
case.
is in the court premise, my lord, but he is not appearing
He
now.
has to appear.
So, my lord, they are enjoying the stay. My lord, this not this interim order may not be continued. That is our prayer. Otherwise, my lord, they don't have any merit in the case, my lord. My lord, what happened, my lord? May I, my lord?
No, then, since the leading counsel is not present today.
Not present, but he is in the court premise, my lord. He is deliberately not appearing before his court.
In
fact, he told me he won't be appearing.
So we'll give him another chance to make appearance if he's again absent.
No, they have not asked for adjournment. They have not, he has not.
Your
asked for
Lordship, you may
That's
order,
what we
you may issue any orders.
It is the,
Okay, you're not praying for adjournment,
yes, my lord.
but you don't want to appear in this matter. What is the case about?
My lord, this tender, my lord, NIT was issued, my lord. Now,
Ah.
NIT, my affidavit in opposition respondent 1, 2, 3, 4, my lord. Now, assessment was carried out, my lord. My lord, may please see.
So listen, so you want to get instructions from your client, whether you want to withdraw the instant writ petition, is it in that form?
Yes, Your Lord.
My lord,
Your-
their
Then-
submission is that, my lord, whatever this court passes on any order, my lord, they will
Ah.
comply, my lord.
So you withdraw, if you don't want to
Yes,
press
ma'am.
your case, you withdraw. It's
Yes,
as
ma'am.
simple as that, so
Yes,
that this court doesn't have the trouble of writing the whole,
Yes,
you
yes.
know, that's
Yes.
what I'm saying.
Yes.
Okay, heard Mr. So-and-so appearing for the petitioners along with
I'm for respondent number 1 to 5, my lord.
Mr.
1 to 4.
So-and-so, learned counsel for respondent number 1 to 4, and Ms. So-and-so.
Respondent 9.
For respondent number
9.
9. The learned counsel for the petitioner submits that they no longer wish to press the instant writ petition. And submits that this court may pass any order found appropriate. Having heard the submission made by the learned counsel for the petitioner, this court finding that the instant writ petitioner is no longer interested in pressing the instant writ petition, find it fit to dispose of the said writ petition. Since it appears that the petitioner is no longer interested in the matter.
No, no.
Accordingly, WPC number so-and-so stands disposed of as above. Yes.
Yes.
I want to hear the whole thing.
Any interim order may be vacated.
In view of the disposal of the instant writ petition number 169/ so-and-so, the interim order passed in this matter is vacated.
Yes.
Yes.